Hello everybody, welcome back to our CMA classes. So let's resume our law class. We were doing insolvency and bankruptcy code. So let's complete this chapter. So here we go. Section 23 is about the resolution professional to conduct the corporate insolvency process. Okay, once we know that IRP, there is insolvency resolution professional, remember, and after the certain things, the COC will decide whether this IRP is to be the resolution professional or not. Remember, for that they have to vote 66 vote, right, in favor to replace this IRP to the resolution professional. Remember, hope so this was clear to you. So let's continue the section 23, which is saying the resolution professional who is going to conduct the CIRP, which is corporate insolvency resolution process. Okay, so which means the resolution professional shall conduct the CIRP who manage operations of definitely of the corporate debtors. The resolution professional shall exercise all powers and perform duties as are vested conferred on IRP, which is exactly right, insolvency resolution professional. An insolvency resolution professional shall provide all the information document related to the corporate debtor pertaining to the resolution professional. Remember where we already discussed in section 22 that if the COC, the committee of creditor, wants to reappoint or want to replace this IRP, okay, in that case they can definitely replace and give the name to A, educating authority. Once this process is done, the A is going to give that name to board. Remember, this was the things we already discussed in section 22. Remember? Yes. So we are talking here about these people, okay? The IRP who was actually appointed, and if they have replaced, the COC have replaced that IRP, okay? In that case, this point is saying about that thing, okay? The IRP shall provide those who was actually appointed, take care, and he have to give all the information, all the documents, all the recording to whom? To the RP. Remember? Hope so this is clear now. Where the COC resolve the IRP and consequently a RP is appointed by A. Remember what I told you in section 22 is all about. So this was the section 23. Now let's go for the meeting of committee of creditors, section 24. Members of COC may meet in either person or in electronic form. There are two ways where a person can attend the meeting, okay? So member of COC may meet in person or in electronic way as may be specified. All the meeting of COC means the committee of creditors shall be conducted by whom? Definitely by the resolution professional now, okay? Hope so this is now making sense to you guys, okay? The resolution professional shall give a notice of this, that this notice, the meeting is going to happen, okay, is going to held in this specified date. So the notice is to be given to each and every members, okay, of the COC, and which include member of COC, member of suspended BOD, board of directors of the corporate person, and the operational creditors. The meeting of committee of creditors shall conduct in such a manner as may be specified. So this was not much in this section, and this is very simple, okay? Section 25 says about the duties of resolution professional, where the duty of resolution professional mean there to function, okay, which to preserve the asset of corporate debtor. Remember, yes, we know this, and to protect the asset of corporate debtor. The resolution professional shall undertake the following action for the purpose of PNP to preserve and to protect of asset of the corporate debtor. First of all, they have to take the immediate custody and control of all the asset of corporate debtors once the resolution professional is appointed, okay? So there is two major duty of RP, okay? First of all, he have to protect and preserve. He have to protect and he has to preserve the asset of corporate debtor, okay? And what are the things which are included in PNP of the corporate debtor, of asset of corporate debtor, which means he have to take, the RP have to take all the immediate custody of all the asset of CD, corporate debtors. Once he have been appointed, the RP have been appointed, he have the power to appoint the accountant, to account the legals, to appoint the other professional in a manner which is specified by board. Okay, and he have to maintain an updated list of claims, and he have to attend all the meetings of COC. Remember, he is the one who have to make give the notice to members of COC. What I said this, okay, and he have to conduct that meeting of COC. Okay, so first of all he have to attend that meeting, right? He is that much important person now. And he have to prepare the information memorandum. So these were the duties of the professional, the resolution professional. Apart from that, he have to invite the prospective resolution applicant and preserve all the resolution plan. Okay, now this is something new to us. We will read this. Okay, so he have to present all the resolution plan at the meeting of COC and such other action as may be specified by board. Let's go for section 27. I hope so. These things are really very easy. That's why I'm not going in depth. Okay, and these are really very much easy. I'm hoping this. Okay, so let's go for section 27, replacement of resolution professional. Is it possible that earlier I told you once the IRP was decided by AA or operational creditor, financial creditor, still they have already replaced in section 22. Remember, the COC have replaced, or they want to appoint somebody else in place of IRP. They want to appoint somebody else as RP, resolution professional. Okay, so is it possible now they can again change the resolution professional? Yes, they can. Okay, so in section 27 we are going to read that replacement of resolution professional by a COC. For sorry, in that section 22, what we read, at least 66% of voting of the COC should be there, right, to change, to replace, to appoint somebody else as RP, right? So that is going to be applied. The same things are going to apply in this section also. Okay, in section 27. So if the committee of creditors is of opinion that the resolution professional is required to be replaced, it may replace with any other resolution professional. Okay, so RP once appointed, once finalized, can definitely be replaced by some other RP. Hope so this point was clear. Take in meeting of COC, a vote of how much? 66% of voting share is required. This is very familiar and this is very easy to us. Okay, now we can understand this very easily. Another point says, before passing a resolution for replacing the resolution professional, the COC, the committee of creditors, shall obtain a written consent from whom? From a proposed resolution professional in a specified form. Let me read this again. The point is saying, before passing a resolution, which resolution? To be appointed another resolution professional. Okay, so before passing this resolution, the replacing resolution from the committee of creditor, the COC have to obtain the written consent. The written consent from whom? From the proposed resolution professional. Okay, so written consent is to be taken from whom? From the proposed RP, the resolution professional, in a specified form. Okay, so the same thing is going to happen. The name of proposed resolution professional is going to be forwarded by whom? By COC, the committee of creditor, to whom? AA, to the educating authority. This is very easy. Okay, another point, same thing is going to happen. The AA, the educating authority, is going to forward that name to whom? Name of proposed the resolution professional to whom? To the board. Okay, for the confirmation. Now what is going to happen? Any dispensary, this is a note. Okay, once this is approved, okay, sorry, let me not jump into the another step. Let me read this. If any disciplinary proceeding are pending against the resolution professional proposed by COC, the resolution preparation already appointed shall continue. The appointment of another resolution professional is made. Okay, so this section is up to this, which is saying under section 27, if the resolution professional, if the COC thinks that this resolution professional should be replaced again, okay, there is a possibility that this resolution professional is going to be changed by some another resolution professional, remember, but how much vote is required for this? 66% of COC. Okay, this is clear. So, and there is one more thing, a written consent of proposed representation resolution professional is to be taken, okay, and that proposed, the name of that proposed RP is to be given to whom, forwarded to whom, to A, and then again A is going to give recommend that name to board, okay. But what if the board have not given any, consent, or they have rejected the name of that proposed resolution professional? In that case, what is going to happen? The person who was actually appointed earlier as RP, resolution professional, is going to make the duties, going to do the further functions, okay. So no reappointment is going to happen until some another resolution professional is appointed, okay. So the proposed proposed RP is not going to, appointment of him is not going to happen there. Hope so this point was clear. Okay, let's go for section 28, approval of COC for the certain action. What is going to happen? The resolution professional cannot act. Sometime he have to take, for some function, for some action, he have to take approval from the COC. Okay, there is some limit. Let's go and read out what are those limit. Under section 28, we are going to read the approval of COC for certain action. The resolution professional during the CIRP shall not take any of the following action without approval of COC. Number first, he cannot raise any interim finance in excess of amount which was actually decided by a committee of creditors, okay. So if he want to raise any interim finance, if it is up to excess amount, so first of all he have to take the approval from the COC. Hope so this point was clear. He cannot create any security interest over the asset of CD, the corporate debtor, okay. Change, he cannot change the capital structure of the corporate debtor. He cannot record any change in ownership interest of the corporate debtor. He cannot undertake any related party transaction. Now we know who is going to be the person who is going to be fall under related party section, remember 188, yes. And he cannot amend any constitutional documents of CD, and he cannot delegate its authority to another person, okay. And he cannot make any change in management of CD or its subsidiary, and he cannot make any change in appointment of terms of control contract of such professional as specified by COC, statutory auditors or internal auditors. So he cannot take any of the actions in some of the cases, in specified cases, okay. He cannot take, if he want to take any action, he have to take the approval from COC. But what if he have actually, without taking approval from COC, have taken that action? Let's go and check out. No such action shall be approved by COC unless approved by a vote of 66% of voting share. So here also 66% of voting is required, okay. If any action, this is what I said, if any of the action for the approval of committee of secretary is required, is taken by resolution professional without seeking approval of COC, in that case such action shall be void. Okay, this is very easy, okay, and very understandable. The COC may report it to the board to take necessary action against the resolution professional. So first of all, if any of the action is taken by him without approval, without taking approval of COC, in that case what is going to happen? The 66 voting power is, voting share is actually required in any of the case by COC. But what if he have not taken approval? In that case, the action taken by the resolution professional is going to be void. Okay, and further the COC would report to board to take immediate action against him, okay, because he have not taken the approval from us, from the COC. Hope so this point was clear. Okay, section 29. Now he have to prepare the information memorandum. Okay, once, what is this? Actually these are the things, once everything is done by him, the RP, some of the information is specified board. and the resolution professional have to make it. Okay, the resolution professional shall prepare information memorandum which is specified by board in such a form and manner. Okay, now duty of resolution professional to provide information to the resolution applicant, okay, which is to comply with the provision of law, which is to protect any intellectual property or CD, okay, and to not to share relevant information to whom, to the third party. Let's go and check out now which person is not going to be eligible as resolution applicant. Section 29A, okay, one of the important section. Okay, 29A says about the person not eligible to be appointed as resolution professional. So person shall not be eligible to submit a resolution plan if such person or any other person acting jointly in connection with is an undischarged insolvent, is willful defaulter in accordance with guidelines of RBI issued under Banking Regulation Act 1949, has been convicted for any offence punishable with imprisonment for 2 years or more under any act specified under 12th schedule, or he have been convicted for any of the offence punishable with the imprisonment for 7 years or more under any other law for the time being in force, is actually disqualified to act as directors. He is prohibited by SEBI from the trading in securities or accessing the securities market. He has been promoter or control of the corporate data in a preference transaction, for undervalued transaction or extortorial credit transaction, or is involved in any fraudulent transaction, has been taken place in of the respect of which order has been made by AA, or he has executed a guaranteed in favor of creditor in respect of CD, which is corporate debtor, and at time of submission of resolution plan has an account or an account of corporate debtor under management, or is having a control of such person or whom such person is a promoter. Okay, so what is this actually? We are very familiar with few of the which the points which are in this section 29A. Okay, so I'm not going in that depth again, okay, because we have already covered few the points in director chapters. Okay, so I'm not going in depth now. So let's go for resolution plan. What is this resolution plan? This is to be submitted by resolution professional. Okay, but first of all, what is going to happen? The resolution applicant have to submit this ticket to whom? To the resolution professional. Then again the resolution professional will submit this to whom? We have to find out now. Okay, so resolution applicant shall submit the resolution plan to the resolution professional. Resolution plan shall be prepared on the basis of information memorandum. The resolution professional shall examine each resolution plan received by him to confirm that each resolution plan provides for the payment of insolvency resolution process cost, which is specified by board. Okay, and it provides for payment of debt of operational creditors, and it provides for management of affair of the corporate debtor after approval of resolution plan, and the implementation of supervision of the resolution plan, and have not any contravened of any of the provision of law for the time being in force, and conform to such other requirement which may be specified. Let me say it again. Okay, so what happens once the resolution applicant have to have finalized the resolution plan? This is to be submitted to resolution professional. Okay, and the resolution professional is done on which basis? The informative memorandum. Hope so this is clear. Okay, so we know that resolution plan received by the person, the resolution professional, is to be prepared on some basis. First, that it actually provide the information of what? Payment of insolvency resolution process cost. Okay. Second, payment of debt of operational creditors. First, payment of insolvency process cost, resolution process cost. Second, the payment of creditors, which operational creditors, and it is not controverted to any of the law. This is also clear, okay, and which is specified by board. So these 4 points are clear, right? Let's go for 2 more points, which says it actually provide for the management of affair of CD for approval of resolution plan. Okay, so this is basically what the done by the resolution applicant. Okay, and it should specify some of the points related to management of the CD even. Okay, and which is again approval by some other person, which is AA. Okay, so what happens, the resolution plan involves so many things: the payment, okay, payment of what, the resolution process cost, of operational creditors, take care of dues of operational creditors. Now we know that it also involves the management of affairs of CD. Okay, afterward the resolution plan is approved. Okay, and the implementation and supervision of resolution plan is also written there. Okay, and definitely it have not contradicted any of the law, and if any specified any other requirement which is specified by law board. Okay, so this was easy, hope so. The resolution professional shall present such resolution plan to first of all COD, ठीक है, for approval, ठीक है, the approval of resolution plan by COD मतलब COC, committee of members, by vote of 66% of voting share of the financial creditor. However, the COC shall approve resolution plan if submitted before the commencement of insolvency bankruptcy code where the resolution applicant is eligible under section 29A. This section, what happens once the resolution plan is made? ठीक है, once the resolution applicant have submitted the resolution plan to whom, the resolution professional. Further, the resolution professional is to be approved by whom, the COC, and with how much voting, 66% of vote. ठीक है, this is clear, hope so. ठीक, and that voting of whom is going to be determined, the financial creditors, ठीक, not the operational here. Okay, the approval of resolution plan here I have written that by CO committee of member by voting of 66% of voting share of financial creditor. This is creditor, ठीक है, creditor. Hope so this point was also clear to you. So we have already read that who is going to be eligible for this, the resolution professional and all, ठीक है, for under section 29A. Hope so this point was clear to you. Okay, let's go for this. The resolution professional shall submit the resolution plan as approved by COC to definitely boom to AA, as I mentioned. Once it is passed, the resolution plan is actually passed by whom, the committee of creditors, by how much percentage of voting, 66% of voting of financial creditors. ठीक है, so that is to be submitted to whom, to the adjudicating authority. Hope so this was also clear to you. Okay, now what is going to happen, that resolution plan which was actually submitted by the resolution professional either going to accept and or going to reject. And what if it is going to accepted, ठीक है, so which people are going to, that is going to bound on which people. So we have to read in section 31 which says the approval of financial plan, resolution plan under section 31. Approval of resolution plan is done by definitely adjudicating authority. Either it is going to be accepted, the resolution plan is going to be accepted or rejected. The resolution plan shall be binding on definitely corporate debtor. Okay, we know this. Definitely going to be bound on employee, member and creditors, whether financial or operational, and CG, SG and local authority. Okay, so what is going to be the consequences of approval of resolution plan? The resolution plan is approved by AA and became binding. The memorandum order passed by adjudicating, remember in under section 14, ठीक है, that is going to be cease, have effect. Remember what I told you under section 14, that the memorandum order passed by A is going to be ceased there. Okay, and the resolution professional shall forward it to whom, to the board, with all recording related to conduct of corporate insolvency resolution process and resolution process plan. Okay, what happens once it is accepted by the A? It is going to be bound on corporate debtors, the members, the employee, the creditors, the CG, SG and local authority. Now we know this, okay? But once everything is accepted and that process, the CRP process and the resolution plan is to be forwarded to board by whom? The resolution professional. Okay, hope so this was also clear. And what is going to be our next step? What if the A have not received any of the resolution plan, right? Resolution plan by whom? By the resolution professional. Okay, what is going to happen? The initiation of liquidation is going to happen. So next section, section 33, we are going to read about the initiation of liquidation. Okay, where the A shall pass an order to liquidate the corporate debtor where the adjudicating authority doesn't receive a resolution plan, where it is to be approved by COC, right? What I said earlier, the resolution, let's be very quick, okay? The resolution applicant have to submit that resolution plan to whom? The resolution professional. Is it clear? Yes, this is clear, okay? What is going to happen? The resolution plan professional have to take the approval of COC with 66% of voting power, right, of financial creditors. And once it is going to be approved by whom? The COC, the resolution professional have to pass that resolution plan to whom? To the AA. And once if the AA have given the approval, it is going to be bound on those people, right? I'm not going in depth now which people, okay? Once it is done, it is bound on those people. What is going to happen again? The resolution professional have to give each and every details of CIRP to board. Along with that resolution plan is to also submitted to the board. Hope so this point was clear, okay? But what if the COC haven't approved that resolution plan? In that case, if the A have not receive any of the resolution plan, okay, the liquidation of the company, the corporate debtor is going to happen, okay? This is clear now? Hope so. Where the adjudicating, let me say it again, when the adjudicating authority shall pass an order to liquidate the corporate debtor where the adjudicating authority doesn't receive any resolution plan which is to be approved by COC. The adjudicating authority shall pass an order writing to the corporate debtor to be liquidated. It shall issue a public announcement stating that the corporate debtor is in liquidation and requires such order to send authority with this is not, okay, and required to be ordered to send to the authority. Leave this part. What is going to happen once the initiation of liquidation is going to happen? The liquidator is to be appointed. So next section says, section 34, appointment of liquidator and fees. Resolution professional to act as liquidator. So those person who was appointed last as resolution professional, okay, can be act as liquidator here, okay, where the A pass an order for the liquidation of corporate debtor under section 33. The resolution professional shall appoint it for what? The insolvency resolution process shall submit of writing by resolution professional with the adjudicating authority in specified form and act as liquidator. Okay, so there is chances of that resolution professional that person can act as liquidator as well. Okay, so hope so this was clear to you. If A is not satisfied, he may direct to board to propose the name of another insolvency resolution professional to be appointed as director, okay, and shall propose the name of another, this is board, okay, and board shall propose the name of another insolvency professional along with the writing concept, written consent, okay, this is consent within 10 days of direction issued by A. Again same thing is written here now. What is going to happen if once the initiation of liquidation order is passed under section 33, remember, so the person who was actually appointed as a resolution professional can continue with specified, with the consent of him, okay, he can act as liquidator. This is super clear, yes. But if the A is not satisfied with that person, what is going to happen? A is going to give, order the board, and board within 10 days, he have to give the name of another liquidator name, okay, who can act as liquidator here, okay. So that is going to happen within 10 days. So this was also clear. Any insolvency professional appointed as liquidator shall charge such fees for conduct of liquidation as it is specified by board. So let's be very quick. Let's read the power of board. power on and duties of liquidator under section 35. ठीक है, to verify claim of all director to take custody and control of all the property asset of the corporate debtor, to evaluate the asset property of the corporate debtor, to carry on the business of the corporate debtor, to sell the immovable property and movable property of the corporate debtor, to draw, accept at endorse of a negotiable instrument, to draw and endorse the negotiable instrument, they are saying, to take out in his sufficient name letter and administrator to the deceased contributory, to opt any professional assistant from any person to investigate the financial affair of the corporate debtor, to take all of the action steps of sign, execute and verify and any paper deeds, receipt, documents, application, petition for such purpose of he can use his name, okay, to perform all other function as specified by board. These are the very common duties which is to be performed by liquidator, and we know this, okay. So I'm not again going in depth, okay. Hope so you are clear. And here comes the last section of this chapter, and this is one of the important section, which is section 53, distribution of asset. ठीक है, the proceed from the sale of liquidation as it shall distribute in the following order of the priority in within such period and such manner once the consideration received from liquidation. ठीक है, so how we have to pay off that amount, so we are going to read in this section. So first of all, it is the payoff in some sequence. So very first thing says about the insolvency resolution process cost, the IRPC cost, ठीक है, which is again liquidation cost, ठीक है. So IRPC cost and liquidation cost in full, it should be paid first. So this is first sequence, ठीक है. Second says the following debt shall be ranked equally, okay, to workman dues for period of 24 month preceding liquidation commencement start. We are only going to take that 24 month from which, from preceding liquidation commencement date, okay. So 24 month of whom the workman dues, okay. Second, the owned, the debt owned, this is debt, ठीक, debt owned by whom the secured creditors, and that secured creditor is to be relinquished with security, okay. So let me write quickly. So that secured creditors should be relinquished security. Hope so this is clear. The very first was of the IRPC cost, liquidation cost, remember. Second, the amount should be equally divided among workmen dues, ठीक है, for 24 months from the date once the commencement of this have actually started, ठीक है, liquidation, ठीक है. So second, the secured creditors whose the relinquishment of security is there, ठीक है, otherwise it's not going to be that give to the that secured person, secured creditors, ठीक है. Third, the wages and any unpaid due on the employee other than workmen for period of 12 months. So those who are not covered under this second point for the workman, ठीक है. So in this third point we are going to give, ठीक है, but for how much month? 12 months. Earlier in workman की case में we have taken 24 months. In this case, other than workman की case में we are going to take 12 months, ठीक. Proceeding from that same preceding liquidation date have commenced, ठीक है. So wages and unpaid dues to employees. So let me write wages, unpaid dues to employees other than workmen dues we have, which have actually covered under second point, okay. Hope so this point was clear. So the fourth point said the financial debt which is owned by unsecured creditors. Fourth says about the financial debt, ठीक, of whom the unsecured creditor. Let me be very quick. First, liquidation cost and that CIRP cost, ठीक है. Second, the amount is to be divided among two people, ठीक है. वो पहला वाला कौन सा? वर्कमैन 24 मंथ्स, ठीक. सेकेंड वॉज ऑफ सिक्योर्ड क्रेडिटर्स, ठीक है, रिलिंक्विशमेंट वाले सिक्योर्ड क्रेडिटर्स, ठीक है. एंड थर्ड इज अबाउट दी वेजेस एंड ऑल of employee other than that second point wale people, ठीक. And fourth is about the unsecured ठीक है, unsecured creditors, financial debt of unsecured creditors. Okay. Fifth, the following due shall rank equally between any amount due to central government, state government, including the amount of received on account of the consideration consolidated fund of the India and consolidated fund of state or any other part of period 2 year preceding the liquidation, or any debt which is owned by secured creditors for any amount unpaid following movement of secured credit security interest. ठीक है, so again here come the secured creditors. ठीक है, so fifth point is about where the amount is to be equally divided among the government, whether the CG, SG and all. ठीक, and second says about the secured creditors. ठीक, and lastly there are three things. If any remaining debt is pending, that should be paid off. Further, if any amount is left, preference shareholder if there is there, then they should be given preference over the equity, last equity shareholder of partner as case may be. Okay, so this was the amount, the distribution of asset from liquidation, ठीक है, under section 53. So first of all, what we read, very first sequence was of what? Liquidation cost, CIRP cost. Second, it's to be divided among two people of the which workman वाले 24 weeks or 24 months, ठीक, from the liquidation's commencement date. Okay. Second, the secured creditors with relinquishment security. Third is about the wages to whom? To the employees other than second point. ठीक. Fourth is about the secured debt of whom? The unsecured creditors. We cannot leave the unsecured creditors. Okay. And fifth is about to whom it should be equally divided among the central government, state government and all. ठीक. And with that, secured creditors. Okay, let me clarify this. Debt which is owned to secured creditor for any amount unpaid following the movement of security interest. So we are going to take this, ठीक, secured creditors other than relinquishment securities. Okay, hope so this point was clear. And if any other debt is remaining that is to be paid, then preference share would be given, and if any amount is left, then equity shareholders would be given that amount, distributed that asset. ठीक है, hope so you get something. ठीक है, this video was informative. Our next video is going to be on corporate governance. Till then you have to stay updated, guys, and do your revision very well. Go for writing practice. That's it. This is Soumya Santosh. We'll meet in our next video. Toodles, guys.